Well, y'all ain't gonna believe this. That is how we South Carolinians always start a story that's especially juicy. And boy, have we got a juicy one for you today. We are being sued by 15 deep blue states and D.C. Why? Because the attorneys general of those states, led by New Jersey Attorney General Matt Platkin, are 100% ticked that we were successful in ending a Biden-era gun control policy. I'm talking, of course, about the Biden ATF's ban on forced reset triggers. The ATF, as you know, had just decided that those triggers were machine guns. Spoiler alert, they are not. And the ATF started seizing them from law-abiding Americans. NAGR sued over that, and we won. Despite that, here's what Attorney General Platkin said when someone raised that exact point to him in response to this lawsuit.
For decades, including post-Bruin, the federal government has considered machine gun conversion devices like forced reset triggers as machine guns.
In U.S. versus Cargill, they extensively covered, machine gun action, and that's settled precedent. And they made it clear that it has to do with the single function of the trigger. Doesn't an FRT require multiple functions of the trigger? It's not
No.
one single function.
No, it is one single function, and we lay this out in the brief. You pull the trigger back and hold it, and it will continuously fire.
Now, of course, he's 100% wrong about that. The district court ruling by Judge O'Connor ordered the ATF to return our members' seized triggers. The ATF was gearing up to fight that tooth and nail and had already appealed to the Fifth Circuit. Then, under the Trump DOJ, there was an abrupt about-face. And instead of continuing to represent that Biden-era trigger ban in court, the DOJ came to the table and we reached a settlement. That settlement said they would stop trying to overturn our court win and would return everyone's seized triggers. Note that I said everyone's, not just NAGR members' triggers, but every law-abiding gun owner's unlawfully seized property had to be returned under the settlement. After all, if the legal basis for confiscating the triggers in the first place is overturned, what right do the feds have to hang on to that seized property? Well, that was the final straw for the 16 gun-grabbing attorneys general. They filed a lawsuit against Pam Bondi, the DOJ, the ATF, and your National Association for Gun Rights, and everybody else that was a party to that settlement. So yeah, we're being sued, along with the Department of Justice, by 16 anti-gun attorneys general to stop the federal government from returning unlawfully seized property back to the owners. It's unreal, isn't it? Now, those states include a lot of the normal offenders: New Jersey, Maryland, Colorado, Hawaii, Illinois, Nevada, Oregon, Maine, Rhode Island, Vermont, Washington, Delaware, Massachusetts, Michigan, Minnesota, and Washington, D.C. Now, here's the summary of their arguments. The NFA bans machine guns. FRTs are machine guns. They're not. So ATF can't go beyond federal statute and distribute them all over the country. So get that. These states are actually trying to argue that the federal government is overstepping its statutory boundaries by returning the triggers, when the ATF actually overstepped its statutory boundaries by taking the triggers in the first place. I mean, the unmitigated gall of these guys is just unbelievable. Now, the lawsuit is asking the judge to stop the return of the triggers to non-NAGR members, if not nationwide, at least in the states bringing the lawsuit, because most of those states have banned forced reset triggers. But the ATF wasn't going to return triggers into a state that bans their possession. All of this with the settlement and everything is federal. None of it affected state bans on forced reset triggers, and if you live in one of those states, first off, you have my sympathy, and second, you are subject to those state laws. So here's what the ATF is saying about that. Some states independently prohibit the possession of forced reset triggers or trigger-activating devices. If you live in a jurisdiction in which the possession of a forced reset trigger is prohibited by law, the ATF will work with you to return the device in a place where it may be lawfully possessed, or, upon request, will transfer the device to a third party who may lawfully receive it. But these attorneys general are just assuming that the trigger owners will not be law-abiding and will bring them back into the banned states, and that there will be death and destruction and mayhem. Specifically, here's what they're claiming will result. Number one, enforcement costs, especially without a list of the FRT owners in these states, which would enable law enforcement to harass them directly. They make a big deal of saying that the U.S. can't hinder a state's enforcement of its own laws, sovereign injuries, and all of that. Number two, public safety harm. There will be massacres and bloodshed in the streets, etc. Number three, healthcare costs. Somebody's got to pay for said massacres and bloodshed in the streets. Number four, insurance premium increases. Because of the healthcare costs from the massacres and bloodshed, everyone's insurance premiums are going to go up. This is what they're alleging. And then the attorneys general claim that they are likely to succeed on the merits because federal law bans machine guns and FRTs clearly are machine guns. But we already won that case, and the court ruled that they are not machine guns. That ruling stands, and trying to pretend it doesn't exist will not make it go away. They conclude by saying this: plaintiffs are likely to succeed on the merits because the federal government lacks the authority to redistribute FRTs across the country. As the Supreme Court has cautioned repeatedly, agencies are creatures of state and accordingly possess only the authority that Congress has provided. Well, where were they when the ATF tried to create law out of thin air banning firearms accessory after firearms accessory? It was crickets from these gun grabbers. But now, when suddenly the government goes, yeah, we couldn't lawfully seize them, so we'll give them all back to the rightful owners. Now, these attorneys general are suddenly all about statutory boundaries and the rule of law? Give me a break. This is the third time this group of states has tried to intervene to stop gun owners from winning in this case. The first time was right after the election, and they tried to intervene to become parties to our lawsuit. The Fifth Circuit smacked them down in 2 hours. Then they tried to intervene to stop the settlement. And that was so ridiculous it didn't even warrant a response from the court. We signed the settlement, the DOJ dropped the case, and that was that. And now we have this, a separate lawsuit to stop the lawful return of your property now that a court has ruled that the ATF couldn't take it in the first place. Now here's where things get a little dicey. The attorneys general judge shopped for a friendly hand-picked venue, and this is who they got. This is the Maryland Federal District Court judge that just brought MS-13 member Kilmar Abrego Garcia back into the country. That legal battle between this gang member and the Department of Justice is still ongoing in her courtroom. She was nominated by President Obama, so yeah. This case should be a slam dunk in our favor. They have a lot of procedural issues with this lawsuit. But if we've learned anything in the last several years of gun rights litigation, the facts don't actually matter nearly as much as who your judge is. So we're going to have our work cut out for us here, and we could use your help. There's a link in the description box below where you can contribute to our legal war chest, and we would ask for your support as we prepare to face off with 16 anti-gun attorneys general. It's going to be fun, y'all. Thank you so much.